Well, hello everyone and welcome. My name is Lior Samfiru. You are watching me now talking about employment law. This is your live employment law Q&A session. So this is the place where you come to find out more about your legal rights. Again, I'm Lior Samfiru. They call me the employment lawyer. I'm one of the founding partners of Samfiru Tumarkin LLP. You can find my firm across Ontario, BC, and Alberta. And I'm here live, like I try to be every week, to talk to you, to tell you about employment law, but more importantly, to answer your questions. So if you're dealing with a workplace issue, if today wasn't a good day, well, let's make tomorrow a better day. And it can start by you asking questions. Can your boss do what it's doing? Is your company allowed to do certain things? Is the ultimatum that you got legal? Do you have rights? What to do if you lost your job? You name it. If it has to do with employment law, if it has to do with your job, with your workplace, you're in the right place to get those answers. So call, or you don't need to call. You just need to type in your question, hit enter, and you'll get all the answers that you need and more. You can ask follow-up questions. Let's have a discussion. Before we get started, let me get you some other contact information. If you want to connect with me and my team across Ontario, BC, and Alberta, off air, off social media, it's very easy to do that. You just go to employmentlawyer.ca. Again, you see that address below, employmentlawyer.ca. Phone number is there, email address is there. You want to fill out a form instead, you can do that there. Also, you can read a lot more about employment law there. It's all there for you, employmentlawyer.ca. But right now I'm live. So you're live, you're watching me. You don't have to just watch. Type in your question, hit enter. You'll see the box there, and I'll see that question and I'll answer it. I'm going to start answering questions right now. Again, joining us, those of you that have just joined us, I'm Lior Samfiru, the employment lawyer, and I'm here live answering employment law questions, your questions. So ask them right now. All right, first question today from Miss Raid on YouTube. I'm dealing with a very difficult coworker and waiting to speak with my director about this. Do you have any suggestions how to handle this? So yes, you need to talk to your supervisor, your boss, the HR, the right person about what's going on with your employee, your coworker, but you want to follow up in writing, in an email, confirming what you discussed. You don't want there to be a question later. Did you have that conversation? What did you say? Was something unclear? You want to follow up in writing, okay? What you're expecting here is for the company to investigate this and then deal with this issue. So talk to them, follow up in writing, and then give them a few days to deal with that. You know, depending on how serious it is, maybe it's a couple of days. If it's more serious, it may need more time. And you can follow up with the company, what's been done, what's been happening on this if they don't tell you. If they resolve the issue, fantastic. If they don't resolve the issue, I want you to call me, okay? You have the right to have those issues dealt with. This is a big deal if you're being harassed, bullied, mistreated in the workplace, so your company has to deal with that. Always follow up in writing. You don't want your boss to say, oh, you never told me, or you said, don't worry about it. So follow up in writing, very important. Any issues, you call me, and to do that, you do that with employmentlawyer.ca. That's the way to contact me. All right, questions are coming in. Ask yours as well. I love getting as many questions as possible. You have time right now. I'm Lior Samfiru. I'm going to answer your questions. Next question is from Penelope Quick on YouTube. If I give 2 months notice to leave my position and my employers want me to leave earlier, do they have to pay me out until the date I gave my resignation letter? Nothing specific in my contract. Generally speaking, the answer is yes. If you give 2 months, the company has to pay you for the 2 months. Really what they have to pay you is the amount of severance that they would have to pay you, or until the date that you are going to resign, whichever is less. I'll give you an example. So let's say you are owed 6 months severance, but you gave them 2 months notice of resignation, right? Well, they're not going to pay you the full 6 months because you're going to resign anyway in 2 months. They're going to only pay you the 2 months. But let's say you gave them 6 months notice of resignation, but severance would only be 2 months for you. Well, in that situation, they'd only have to pay the 2 months. But generally, Penelope, the answer is yes. They have to pay you the amount that you are going to work. If they don't, you call me. Usually a quick letter from me gets this resolved right away. Hopefully that makes sense. If I've confused you for whatever reason, Penelope, feel free to ask a follow-up question. I'll be happy to clarify. Thank you for that question. Great questions to start off with. Again, for those joining us, my name is Lior Samfiru, the employment lawyer, and I'm here for you answering your questions live. Tons of time still. So ask your question. Give me that chance to help you. All right, let's see. Mike has our next question. I went on a job protected leave due to stress and was off for 16 weeks. My return was July 31st, and my employer wouldn't answer the insurance company or me on my return. 3 days after I was to return, I sent a follow-up email. 9 days after I was to return, they finally returned my email saying they're working on a plan. 14 days after that, they told me I cannot go back and offered me 3 months severance. I've been working there for 18 years. Oh my God, with a clean work record. There's a lot wrong here, Mike. So let's start first of all with the fact that they have to make all efforts to bring you back. Now, that means that they have to look either at the same job or a similar job. They have to go through that process, even if they have to accommodate you, maybe modified duties, modified hours. They have to do that. Now, if they've tried, if they've looked, if they've made all efforts and there's just nothing available, then can they only let you go? Keep in mind, though, here's the big thing. You are owed a lot more than 3 months after 18 years. You could be owed as much as 20 to 24 months of severance. So not 3 months, 20 months. So we potentially have a human rights violation here, because if they didn't try it hard to find a job for you, that's a human rights violation. We definitely have a wrongful dismissal because you're owed a lot more than 3 months. So Mike, this is illegal on several levels. Now that you know that, you absolutely have to take the next step. The next step, easy. You reach out to me off air. Let me get this resolved. Let me get you the compensation that you're owed. There's a lot at stake for you. So Mike, to connect with me, my team, easy to do, employmentlawyer.ca. You see that address right here, employmentlawyer.ca, phone number, email address. Just reach out. We'll take care of it, okay? Wrong what this company is doing. I've seen this many times. We'll get this resolved, okay? So Mike, employmentlawyer.ca. And absolutely do not resign. Do not do anything, Mike, until you call us, okay? employmentlawyer.ca. Fantastic questions. This is why you ask questions. Mike was offered 3 months pay. He's owed 20, maybe 24 months pay. That's a significant amount. So that's why you have to make that call. That's why you have to send that email. Or you just ask the question right here, okay? employmentlawyer.ca to go after. Right now I'm live answering your questions, so ask them. All right, next question today from Pesach Baby on YouTube. She says, I don't need legal assistance for now. However, should I need one, how quickly do you respond? Where employer requires immediate signature when a severance offer is provided. So let's start first of all by the fact that the deadline that your employer is giving you on your severance offer is irrelevant, okay? So your employer may say, we need you to sign back by Friday. That doesn't matter. It's irrelevant. Your legal rights don't expire Friday. In fact, your legal rights don't expire for 2 years. That deadline is just a pressure tactic, okay? A pressure tactic. That's all it is. The company wants to scare you by giving you this deadline so you feel you have to sign when they're really offering you a lot less than what you're owed. So don't worry about that. Oftentimes people call me very concerned. Oh my God, my severance package is expiring tomorrow. I need to talk to you immediately. What I say is don't worry about it. Go on a trip if you need to. It's absolutely fine. Your legal rights don't go anywhere. Now, but to your question, how long? We try to call everyone back within 24 hours, okay? Very quickly, and to schedule appointments as soon as possible. But that deadline is meaningless. Don't worry about it. Ignore it. It doesn't do anything, okay? Hopefully that makes sense. Any follow-up, you call me, employmentlawyer.ca, to connect with me and my team. Getting the best questions today so far, guys. Let's make them even better, even more. You have an opportunity for those joining us. I'm live here. My name is Lior Samfiru, the employment lawyer. I'm here live answering questions. Great questions have come in. More are coming in right now. Don't wait till the last minute. Every week, I say this every week, but every week it's true. People ask me questions right at the end. I don't get to answer them. Don't let that happen. You can ask questions. You have plenty of time. Questions, follow-up questions. You can take your time, but do it now. All right. Next question from Reggie on YouTube. My brother's employer has claimed he was responsible for a workplace accident and are letting him go. He had nothing to do with this and hasn't had any problems before. He's there for 8 years. What should he do? Is this a wrongful dismissal? What he should do is actually very, very simple. call me, right? That's what I do for a living. You call me or he calls me and I help him. Here's the thing. The company has to prove that he was responsible for the workplace action. The workplace accident. He doesn't have to prove that he wasn't responsible. Company has to prove that he was. Well, if he didn't do it, they can't prove it because it never happened. So he's owed a heck of a lot severance. Now, if he's been there for, I guess you say 8 years. Let me just see. Yeah, 8 years. Well, I don't know about what his job was. I don't know how old he is, but he could be looking as much as a year's pay. Okay, depending on those factors. So what does he do? He calls me. Yes, if in fact he's not responsible for this accident, and if he doesn't get the severance that he's owed, yeah, that's a wrongful dismissal. The good news is it's not going to be difficult to resolve. So Reggie, you have your brother call me. Have him go to employmentlawyer.ca. Good timing. You see that right here, employmentlawyer.ca. My email address is there. My phone number is there. It's all there. Have him connect with me. But let's do this now. Okay, let's make sure that he gets his compensation now. I'm sure if he's like the rest of us, he has bills to pay, etc. So let's make sure we don't wait on this. Good question, Reggie, and tell your brother what to do. Fantastic questions today. You see how easy it is? No judging here. There's no bad questions. No such thing as bad questions. There's only answers, information, and solutions. All right, continuing. Next question comes to us from Debbie on Facebook. Nice to have someone from Facebook. Is there a time limit once you are terminated to go after severance? So as I was saying before to one of our viewers here, there's a 2-year period during which your legal rights are staying alive. So your legal rights don't expire for 2 years. That means there's a 2-year limitation period. So if you've been let go, you have up to 2 years to pursue your entitlements, your severance, your termination entitlements. Now that is a very strict 2 years. It's not kind of 2 years. It's not, about 2 years. It's exactly 2 years. So 2 years and a day, too late already. So don't sit on your rights. If you were let go at some point in the last 2 years, chances are, even without me knowing anything about you, chances are that you're owed more than what you were paid. Now, if you signed off on that severance offer, unfortunately, I can't help you. If you didn't sign off on anything, they just paid you something or they didn't pay you anything, if it happened in the last 2 years, you can still do something about it. All right, then you reach out to me, reach out to my team through employmentlawyer.ca, and we'll take care of you. Now, we've talked about severance. We talked about losing your job. Question always becomes, well, how much severance am I really owed? How do I know if I'm owed 6 months or 8 months or 24 months? How do I know? Well, I'm going to tell you how you find out right now if you want. You grab your smartphone, you grab your tablet, your desktop, your laptop, doesn't matter. As long as you have internet connection, and you go to pocketemploymentlawyer.ca. Hey, good timing, right there. Pocketemploymentlawyer.ca. Why do you go there? Well, because one of the tools that we have there, in fact, you'll see it as the very first tool, is the severance calculator. I created this tool some years ago. Over 2 million people have used it. And the severance calculator does what the name says. It tells you and it calculates your severance for you. It's easy to use. It takes a few seconds, literally seconds. You don't have to sign up. You don't have to put in your name. You don't have to put in the company's name. No credit card, no phone number. It's just there for you, completely free, completely anonymous. People get shocked when they use it and they see just how much severance that they're owed. Well, you don't have to be shocked. Check it out yourself. And if you ever lose your job, probably one of the first things you want to do, even as you're walking out to the elevator, go to grab your phone and go to pocketemploymentlawyer.ca, use the calculator, and get a sense of what you are owed. You can also contact me directly from the Pocket Employment Lawyer if you want. So check it out. There's many other things you can do there as well. So pocketemploymentlawyer.ca, it's like having a lawyer. It's like having me with you on your phone, in your pocket at all times. But right now, I'm live still plenty of time. So ask your questions. I'm going to continue answering questions right now, but you have time. If you've just joined us on this employment law session with me, Lior Samfiru, you can ask questions and get answers about employment law. All right, let's see. Question comes to us from Carla on YouTube. What determines getting minimum versus full severance pay in Ontario? So every employee is owed full severance unless they sign an employment agreement that limits their termination entitlements. Here's the thing. even those employees that signed employment agreement that limits their entitlements, most of them are still owed full severance because for various reasons, those contracts are very often not enforceable. So you may have signed an employment agreement that that limits your severance. There's probably an 80% chance that it doesn't actually limit you, that you are still owed your full severance. So most people, the vast, vast, vast majority of people, when they lose their job, they're owed their full severance. And that could be as much as 2 years' pay. Oh, and by the way, even if you only worked for a few months, you didn't work for very long, 3, 4, 6 months, even in that situation, your severance is measured in months, not days, not even weeks, in months. You could have worked for 6 months and you could be owed 6 months severance. Okay. That's why you call me. That's why you go to the severance calculator. Again, you find it at pocketemploymentlawyer.ca. Chances are you're owed a lot more than what you've been offered. Great question. Love those questions. All right. I think we have some follow-ups here from Pasco Baby. I've been with the company for 20 years. When I was promoted 5 years ago, my promotion letter included a clause that should the company terminate my services, that my severance is limited to a maximum of 12 months. Is it binding? Well, I'd have to see it. So the devil is in the details, okay? So we'd have to actually see this. I'm going to give you an 80, even without looking at it, I'm going to give you about an 80% chance that it's not binding, it's not enforceable, and that you can get your full severance, which could be as much as 24 months pay. But I would actually have to see it and read it myself. Once I read it, I can tell you in 30 seconds whether or not it does limit your entitlements. But there's an important message here in the lesson. Be careful with what you sign, okay? Sometimes a company is going to try to sneak in a termination clause, sneak in something that could limit your future severance. It could cost you tens of thousands of dollars. So be very careful. If you're already working for a company and the company wants you to sign a new employment agreement, don't, okay? Be very concerned. Let me see it certainly before you sign it. Chances are that there's terms in there that are going to be very problematic for you, okay? So be careful with that. So thank you for that, Basic Baby, and have a follow-up question again? No problem. Ask it. All right. Leanne, if I'm mispronouncing this, let me know. Sorry. Has a follow-up or has a question on YouTube. My partner was let go from his employment as a tow truck driver without notice and without severance. They decided to change the procedures without notice. Also, does he have a wrongful dismissal case? Well, if he was let go without severance, absolutely he's owed severance. And that's what, by the way, a wrongful dismissal is a situation where you were owed severance, but you didn't get it. That's a wrongful dismissal. So Leanne, yeah, unless your partner did something terrible, like he stole, he hit someone, he committed fraud, unless he did that, if they want to let him go, they're allowed to, but they have to pay him severance. Okay. And I don't know how long your partner's worked there, but tell them to go to pocketemploymentlawyer.ca, use our severance calculator, and then call me. Okay. Let's get him a severance. It's not complicated. A letter from me, often it's all that's required to get it done. So yeah, of course he's owed severance, and we should absolutely help him get it. So you know what to do, Leanne. Contact information you can find at employmentlawyer.ca. All right. Let's see. Next question comes to us from Paul on Facebook. My former employer sold the business to a new company who does the same work. Most employees were offered positions with a new owner, but some were not. Are the employees who were not offered positions entitled to severance? Who is responsible for paying that? Yeah, absolutely. If you lose your job as a result of a sale of a business, you're owed severance. Absolutely, you're owed severance. It's because it's a termination of your employment. If you lose your job, doesn't matter why. If you lose your job, you're owed severance. And in the sale of a business situation, the seller, the company that's selling the business, is the one that's required to pay the severance. If you never work for the buyer, you have nothing to do with them. The seller has to pay your full severance. And again, if those employees have not gotten severance, they're owed that, depending how long they've been there, it could be 2 years pay. So if you know of these people, Paul, that lost their job, even if they were offered severance, have them call me, and have them call me right away. My phone number, my email address, you can find at employmentlawyer.ca. Again, employmentlawyer.ca. All right, Leanne, who's talking about her partner who lost his job as a tow truck operator, says he was there over 3 years. Well, if he was there over 3 years, he probably is owed 4, 5, maybe even 6 months severance. Okay, so very important to have your partner give us a call. Happy to help him. Let's make sure we get this resolved right away. I wouldn't wait on that, Leanne. Great questions today, guys. We still have some minutes left. You guys still have some time to get in your question asked, to have me answer it. You see, I've been doing this for the last 21 minutes. You see how easy it is, right? I'm just reading them, I'm answering them, and I'm arming you with knowledge, the knowledge you need to have. It's so important to have that knowledge. No one can take advantage of you if you know your rights. No one can take advantage of you if you know what's legal, what's not legal. That's the purpose of this session. So to make sure that no one takes advantage of it, that no one gets away with anything they're not supposed to get away with, all right? Sometimes employers, I got someone the other day who got very upset at me because I tell employee their rights, and you know, some employers are good. But here's the thing. I don't have a stake in this. What I mean is the law is the law. I just tell you what the law is. If the law says an employer is allowed or not allowed to do something, I just tell you that. So to get upset at me for telling you what the law is not very smart, right? Are you going to get upset at your doctor for telling you you have a medical condition? No, he's just telling you what it is. Well, I'm telling you what the law is. That's what the purpose of this session. Again, I'm Lior Samfiru, the employment lawyer. Ask your question. We still have some time. All right. We got a question on Twitter from Mac. Can you please explain why unionized employees cannot sue their employer? Can this be challenged? Well, you can't sue your employer if you're a unionized employee because that's what the law says. That's what the Labor Relations Act says. You cannot sue your employer. By becoming unionized, you give up the ability to sue your employer. You also give up the ability to deal with your employer on your own. The only one that can deal with your employer is your union. And the only thing you can do if you have a legal issue with your employer is to have the union file a grievance. So everything you hear me say on these sessions does not apply to unionized employees. Does not. Nothing that you heard me say today applies to unionized employees. Only to non-union employees. All right. If you're a unionized employee, by law, the only one that can represent you, the only one that can help you, advise you, etc., is your union. You can't hire me. You can't hire another lawyer. You can't take legal action outside of the union process. Okay. So that's how the law works. It's not my opinion. It's simply the law. All right. Good question. Let's get some more questions answered. Norman on YouTube has a question for us. I got hired by a very small company and signed a contract. The contract hadn't established a pay frequency. After a week, I asked my employer if he will establish a monthly pay frequency, and he said no. Then he terminated my employment since he wasn't planning on paying me. Can I pursue this legally? Well, I mean, you obviously know the answer to that, right? You obviously know that you can. Number one, your employer has to pay you for the time that you worked. And number two, you even may be owed some severance. For this, frankly, the best place to go is the Ministry of Labor. It's free, it's fast, it doesn't cost you anything. You can't go there in a normal situation to get your severance. In your case, because you've only been there a week and what you really are owed is payment for the time that you were there, unpaid wages, Ministry of Labor, okay? You can go and file a complaint there. They'll get that compensation for you. There may be additional damages. If you're asking to get paid and because of that you get fired, that's what we call a reprisal. Okay? You're getting punished for standing up for your rights. That's illegal. All right, so there's that as well. Obviously, this is completely illegal, Norman, so hopefully this helps. Any follow-up questions, please feel free to ask. Again, those joining us right towards the end of the session, welcome. My name is Lior Samfiru with Samfiru Tumarkin LLP, answering questions about employment law and workplace rights. I'm going to continue doing that right now. You got last few minutes, so you can still squeeze in a question before the end of the session, so do that right now. Let's see. Next question comes to us from Sam. My wife has been working for a company based out of Las Vegas. She's in Ontario. Her employment contract says that she works at will and is not owed any severance. Nonsense. Okay, there's no such thing as at will employment. They may have that in Las Vegas in the United States. No such thing as that in Canada anywhere. Because your wife works in Ontario, physically is in Ontario, the laws of Ontario apply to her. It doesn't matter where the company is based out of, doesn't matter what she signed. So yes, she is not an at-will employee. She is owed severance, and there's nothing to worry about there. If in fact she ever loses her job, Ontario laws are going to make sure that she gets severance. I'll be able to help her. It's not even going to be difficult. So nothing to worry about. It's kind of, frankly, fairly dumb, honestly, for a company to think that in Ontario they can apply the laws of another jurisdiction. Ridiculous. Doesn't work that way. All right. So the laws of Ontario apply to her, Sam. And any problems, you know what to do. You can reach me through employmentlawyer.ca. Again, employmentlawyer.ca. All right, let's see. Best name of the day so far. Peaceful Relaxation has a question on YouTube. I love that name. I love Peaceful Relaxation. What kind of employment rights do people who are employed by the Canadian Navy have? Do they receive severance if they're let go? Yes, they do receive severance even in that situation. There's a few special rules that apply for Navy employees, but yes, severance would still be paid absolutely. If you're an employee and you lost your job, you're owed severance. And I get asked often, are there particular jobs that don't get severance? Now, if we're only talking about non-union jobs, full-time, part-time, temporary, frankly, every employee that if they lose their job, they're owed severance. The only time you may not be owed severance is, let's say you're a seasonal employee and you're let go at the end of the season. Well, then, yeah, you may not be owed severance. But in most cases, yeah, you're going to be owed severance if you lose your job. Doesn't matter what kind of job you have. Now, last question for the day comes to us from Deanna on YouTube. I went on a disability leave for 2 months. When I tried to return to my job, my employer said my position was filled and they will keep me posted. What can I do? Well, it doesn't work that way. Number one is they have to try to find a job for you, Deanna. If they can't, it doesn't exist. There's no such thing as keeping you posted. At that point, they owe you severance, okay? They can't string you along. Well, let's see what happens. They owe you severance. So we may have potentially a human rights issue here. We certainly have a wrongful dismissal. An employer can't tell you, well, you're not going to work. We'll figure out something. We'll get back to you. No, if you're not working when you should be working, that's a termination. You're owed severance. There's no middle ground here. Okay, so Deanna, you want to connect with me again through employmentlawyer.ca. All right, this half hour flew by. I think I've gotten all the questions answered. Thank you so much for being here with me today. Thank you for asking all these great questions. That's what I always look forward to every week. I'm going to turn off my computer here, but I'm not going anywhere. Okay, I'm getting back to work. You can still connect with me now, later today, tomorrow, next week through employmentlawyer.ca. Check out our website. Also, we have my colleagues also doing sessions later in the week about disability, about employment law. So we're there for you if you have questions. Again, thank you so much for joining me. I'm Lior Samfiru. Always a pleasure to be here with you, and we'll talk to you again very soon. Thanks.